Hello learners, welcome in the class of a company law. This is a unit 2, that is incorporation and its consequences. In the unit 1 we have read about the companies, their types, and how a private company can be converted into public company and public company into private company. In this unit we will learn about the incorporation and its consequences. As we discussed, on the basis of corporation there are two type of companies. One which is unincorporated, which means which has not been registered under the Companies Act 2013, and the unincorporated companies, which means the companies which has been incorporated under the provisions of the Companies Act 2013. So the legal basis for incorporation is provided in the sections 3 to 22 of the Companies Act 2013, which provides for the detailed outline of legal formalities for forming different type of companies, that is one person company, private company, or a public company. So as we knew in the previous class, the types of companies, so the companies which can be incorporated in the Companies Act are one person company. This is a new concept introduced under the Companies Act 2013. In this there is only a single shareholder member in the company, and when on the basis of a members there is minimum two number of members in a company and a maximum of 300 members, and they cannot invite the public to subscribe for shares, then that is a private limited company. And when the company can open its shares for public offering and the minimum number of members in the company is 7 and there is no fixed maximum number of members, then it is a public limited company. One more type of a company that can be incorporated is a non-profit company. Means the company working in the field of art, science, charity, religion for the uh, benefit of a society or some common object. In this type of companies, the profit are reinvested in the company and the profit is not distributed among the shareholders. So for the incorporation, what are the basic requirements? Uh, so there are some basic requirements as has been prescribed in the Companies Act of 2013 are the minimum number of directors and shareholders. So there is a specific provision regarding the minimum number of shareholders and directors in a company. In one person company there is only one member, and there is a minimum prescription for a one director in a company. For the private company it is mandatory to have a two directors in the company and a minimum two number of members, and the maximum of number of members in the private company can exceed up to 200. Then the public company, in this there should be minimum three number of directors and the minimum number of members in the company can be 7, and there is no maximum limit for the number of members in the public company. This is the basic requirement, that is the number of shareholders and directors to incorporate the company. The other necessary things are the company should have a unique name. The company should not use any already registered name of a company, because it can be confusing or there can be a issue of a trademark. So the to incorporate a company should have a unique name. Company must have a physical address, and that is registered office. This is a third basic requirement, which is a registered office. Means there should be a physical address for its registered office to make official communication. And there are some documents required to incorporate uh, company, and those documents are the memorandum of association. Means that it is a type of legal document which introduces the relationship of a company to the outsiders. And the another document which is required to incorporate a company is the article of association. In the article of association there are detailed description how the company will be managed in the indoor relationship, that is the management of a company, administrative functions of a company mm, are drafted in the article of association. Other some documents are the proof of identity and address for the directors and shareholders, the consent of the directors, proof of a registered office address. So these are the basic requirements to incorporate a company under the Companies Act 2013. Now the steps to incorporate a company. So the steps to incorporate a company are, now the company under the Companies Act, it has been made electronic to apply for the incorporation of a company. So you can obtain digital signature certificate, that is a first step to incorporate the company, and it is being done online, and it will be issued for the all proposed directors to sign electronically. The another step to incorporate company is to obtain director identification number. It has been uh, mandated in the act that every director should have a unique identification number. So to incorporate a company, one should obtain a director identification number by filling form dir 3. Then there should be a name approval of the unique company name. Registrar of the company should approve the unique name of the company. The third is to prepare memorandum of association and the article of association. These two documents are the basic fundamental documents to run an company under the Companies Act 2013. Then the application will be filled with the registrar of companies. uh, the application will be submitted with all the necessary documents to the registrar of companies, and the form is titled as the SPICE, which is a simplified performa for incorporating a company electronically. And when all the documents are submitted to the registrar of companies, the registrar of companies will issue the certificate of incorporation and the seal of the company. When the certificate of incorporation is issued, from the same date the company is a legal body. As we discussed the documents for incorporation, so these are the specific provisions, that is the proof of registered address, proof of identity and address of director, consent of directors, articles of association, memorandum of association are the documents needed to incorporate. Then the forms which are involved in the incorporation process, these are the forms which have to be filled to incorporate a company. These have been made electronically available. So there are requirements uh, of a compliance before and after the incorporation of the company. So before the incorporation, you need to obtain all the relevant documents uh, which fulfill uh, which fulfill the need under the Companies Act, and The post incorporation, some compliance which are needed is to register with the GST, to appoint the auditors, to maintain a statutory registers, to fill annual returns, to hold annual general meetings. These are the compliance which incorporated company has to follow. As we discussed, the documents which are needed to incorporate the company, the two documents that we discussed was the Memorandum of Association and the Article of Association. There is a difference between these two documents. So the Memorandum of Association is a legal documents which sets or drafts the company's constitution. It defines the purpose and the relationship of a company with the outside world. It outlines the fundamental conditions and the scope in which the company's activities will be done. So the Memorandum of Association is a drafted outline how the company's relationship will be with the outside world. So the importance of MO is that it defines the company's objectives, it governs external relationships, it sets boundaries, it defines liability. Liability can be two types, that is limited and unlimited. The key clauses which should be in the Memorandum of Association is the name clause. It should specify whether the company is public company or a private company. It should address the registered office details. It should have the objective clause of the company. Memorandum of Association should have a liability clause, capital clause, and the subscription clause. Then the another document is the Article of Association. It is another document needed to incorporate the company. The Article of Association is also a legal document and it governs the internal management of the company. So the difference between Article of Association and the Memorandum of Association in a broad way is that the Memorandum of Association is a document which governs the management of a company, relationship of a company with the outside world, whereas the Article of Association is a document which governs the internal management of the company. It deals with the company's day-to-day operations. The importance of the AO is to govern the internal governance, to fix the rights and duties, powers of the directors and shareholders, to offer mechanism for dispute resolution. It can be arbitration, conciliation, or the mediation, and it should have a provision regarding how the Memorandum of Association can be altered. So the key clauses which should be in the Article of Association are regarding the share capital and variation of rights. It should have a definite provisions regarding the board of directors. Provisions should be regarding the meetings and votings. Provision regarding the dividend distribution in the company, regarding the borrowing powers and the transfer of shares. To understand the difference between the Memorandum of Association and the Article of Association, this chart specifies the difference on the basis of purpose. The main purpose of MOA is to define the company's objective and scope of activities, whereas the AOA is to contain rules of internal management and governance. MO is related to external relationship of a company. Article of Association deals with the internal management, whether of directors, shareholders. MOA's legal standing is that it defines the company's constitution and powers, whereas the Article of Association provides for the internal rules to conduct business. The alteration in the Memorandum of Association can only be changed with the approval of the shareholders and the government. And the article of association can easily be amended. And these two documents both are necessary to incorporate a company. Yes, so altering article of association is easy and it can be altered by passing a special resolution in a shareholders meeting. And article of association should be filed with the registrar of the companies. And similarly, the memorandum of association is a special resolution passed by shareholders in a general meeting, and certain clauses like object clause and the central bodies eh, are defined in the MOA. Another thing which is in our unit 2 syllabus is regarding the promoter, their definition, power and duties. Promoter is defined in the Companies Act of 2013 in subsection 69 of section 2, which clearly defines that the promoters are the person who directly or indirectly takes the initiative to form the companies. Means the promoter he is a person who is motivated to form a company, who is involved or initiative or is an entrepreneur to form a company. He is a promoter. He guides or he influences the business in the early days. He prepares the ground. Promoter is a person who prepares the ground to incorporate the company and how the initial business will be set up. Roles and responsibilities of promoters. Promoter is a beginning of a company. Means the company is started when the promoter has taken initiative. So there are the role and importance of the promoter is very important. A promoter has to incorporate a company under the registrar of companies. Promoter has to raise the capital uh, through shareholders or investors to run a company. It is also a role of a responsibility of a promoter to appoint initial directors who will manage the company's day-to-day operations. And it is a duty of a promoter to define the business objectives, scope, and length of a uh, company. It is also a duty of a promoter, responsibility of a promoter to prepare for the business, how the business premises and everything will be operated. So the role and responsibilities of the promoters are foundational and the beginning. There are some types of promoters defined on the basis of their nature, which are the first promoter. First promoter is the original promoter who has started up the business or who has taken the initiative firstly to form the company, to incorporate the company. Then subsequent promoters, the individuals or entities who become promoters after the company is incorporated and play a role in expanding or developing the business further is subsequent promoter. Then there are professional promoters. Uh, they are expert in business management or they are expert in the legal practice who are hired to act as promoter for the especially in the large corporations. There are corporate promoters. They are the founders of the another company and often seen in joint ventures or holding companies. So some duties of promoters. There is a duty of a promoter to act in good faith, to act honestly in the best interest of the company. The duty of a promoter is to disclose material facts or the facts that could affect the decision making process to the potential investors of the company. It is a duty of a promoter to avoid conflict of interest. It is also a duty of uh, promoter to ensure compliance of the provisions of a Companies Act or the SEBI or the rules forming body. There is relationship. Promoter is related to the company before the incorporation and also after the incorporation. Before corporation, promoter is keenly interested in incorporating the company, and after corporation, the promoter is in the transition position of a director or a shareholder or a key manager of the company. So the promoter is always uh, in the prominent role in the company's operation and the growth. There are legal implications for promoters, that promoter also has a liability for pre-incorporation contracts. Promoters uh, are liable for the fraud and damages because of the representation misrepresentation. Promoters are also liable for the fiduciary duties which he owe towards the loyalty and care of the company for the best interest of the company in all times. Promoter must disclose any personal interest a transaction entered into the company, so there should not be a conflict of interest by the promoters. A promoter has all time interest in the company, and this interest can be defined in three types. That is the financial interest. Obviously, the company is formed for the purpose of earning money, so the promoter hold shares in the company and often have significant stake uh, during the early stage of a company. So promoter have a financial interest, promoter have a management interest, they hold a direct role in decision making and strategic planning, they have a economic interest as initial shareholders, and they are strong companies profit sharing in growth property. Promoters can exit after the company has incorporated. Promoter can exit by selling their shares to other investors in the open market. If the company is a public company, promoter can resign from directorship. Promoter can also step down from management roles or directorship positions as the company grows and matures. Transfer of control. Promoter can share his transfer of control and keep on investing in the company. So promoter is a crucial in the formation of a company, incorporation of a company, and a growth of the company. So this unit 2, that is incorporation and its consequences, in this we have learned about the documents necessary to incorporate a company, and about the memorandum of association and the article of association, and also about the role of a promoter, their duties and responsibilities. Thank you. It was all in the unit 2 of a company law.